Right. I'm going to talk to you about what FDRC is, what our services are for investors, what's mediation, arbitration, and a bit about the G20 high-level principles on financial consumer protection. Okay, what is FDRC? Of course, our full name is the Financial Dispute Resolution Center, and we are non-profit. We have charitable status, so we were opened last year on the 19th of June. So what we do is we promote settlement of disputes by way of mediation first, arbitration next. So only if the mediation doesn't succeed, you can go to arbitration. What we administer is an independent and impartial financial dispute resolution scheme. And we help resolve financial disputes between individual customers and all the different financial institutions. Right. What sort of services do we have for investors in Hong Kong? We do have a hotline. It's free, so please call the number 3199-5199. We run free information sessions, so if any of you are interested, please let us know. You know, we have all the sessions. Go to our website. We have the sessions put down. We also have free investor face-to-face appointments. So a number of investors call us up. They are not sure whether they want to go with mediation, what they're going to do in their case. So they come in with their files and everything, and they come talk to us. It's all free. If the investor decides to apply for mediation, there is a $200 fee. And therefore, we then provide the mediation services and the arbitration services. As Tony said, the investor, maximum loss that people can claim is only $500,000. That's been a big problem for us. It's a very limited intake criteria. So if you've lost more than $500,000, you may not want to give up the rest. So people who have lost more than $500,000, they're thinking, oh, wow, I lost $1 million, so I don't want to go to FDRC, that sort of thing. But it was a figure that was put together by the government based on 80% of the complaints going to HKMA in those days, in 2009. So it's something they thought maybe if 80% of the cases are 500,000 and below, that would be a good figure. But really, right now in this time in Hong Kong, it's really, I think, too low. So I'm going to have to go back and say, let's increase it. We cover individual investors and sole proprietors only. We don't cover companies. And this morning at morning tea, I've had quite a number of people come to me and say, but it's very common in Hong Kong that people use companies to invest. So that's another thing we could look at. We cover claims against all financial institutions regulated by the HKMA and SFC. Okay, so those of you who are regulated by these two regulatory bodies, you are our members. So it's a membership organization. Some of you don't know you're my members, but you are. I've had calls, people come, call me and say, I didn't apply to be your member. I said, well, your code of conduct has changed, for SFC people, and the licensing conditions if you're regulated by the HKMA. So you're all members. Except, of course, Moody's and Standard & Poor's, sort of credit rating services, those agencies are excluded. The claim has be of a monetary nature, which means that we don't take claims which are service oriented. The teller was rude to me, we don't take that. But mind you, the South African one does. They take all sorts of claims, monetary or otherwise. Limitation period. Now, this is another big issue for us. The limitation period in our terms of reference, in our intake criteria, about what cases we can take is very limiting. It's got a 1-year limitation period. So even though in the first 6 months of operation in 2012, since we opened, we've had over 1,000 calls. People with issues, people with problems, consumers who needed some way of resolving their disputes with banks and securities firms. But, it was more than a year since they knew they had the loss. So because of this very limiting 1-year limitation period, we were not able to take on their cases. So it is very restrictive. And as you know, in Hong Kong, the civil law is that you've got 6 years limitation period. So this obviously is extremely narrow, right? So in the end, even though we had over 1,000 calls in that period, we only had 16 applications, which is really far too low, right? In Taiwan, the Taiwanese Financial Ombudsman Institution, which was open last year, same as us, but in January last year, they have no limitation period. So they have thousands of cases, including a lot of the Lehman Brothers cases, right? And the other thing is, we don't include insurance, the insurance industry. Again, in Taiwan, they include all the insurance industry, and therefore they have a lot more cases than us. So we're just sort of starting small, but hopefully government will think that we should be the one-stop shop for dispute resolution in Hong Kong and add insurance to our portfolio. We do provide experienced mediators with training in financial products and selling process. So it's a very specialized area. These people have to be mediators and also have to be trained in what the products are and what the selling processes are. Okay, mediation itself, I think it's a very useful way to resolve disputes because we've been talking about question of trust. Paul this morning talked about the survey. It's very telling. 98% of CFA professionals think that there is a lack of trust now in financial institutions. Mediation is a very good way, that we try to restore trust through communication. It's confidential, it's efficient and effective, there's consensual agreement, we have an impartial mediator, we are under the mediation ordinance, okay? The law covers it, and the mediated settlement agreement is enforceable. I think mediation is an extremely good process. I was the one in New Zealand who helped to start the mediation process for all human rights complaints, and it's very, very useful. If mediation doesn't succeed, the claimant can choose to go to arbitration. For arbitration, again, it's confidential. You have the investor's choice, right? The investor can choose not to go to arbitration, can go straight to court. It's up to the investor. It's a documents-only arbitration, which means that, there's no hearing, okay? There is impartial and independent arbitrator. The whole process comes under the arbitration ordinance of Hong Kong, so it's covered. And the arbitral award that is awarded is final and binding on both parties. So you have finality to it, just like in a court litigation. Okay, just very quickly, G20 high-level principles. So the G20 finance ministers and central bank governors, they called for the OECD to prepare principles for consumer protection and financial services in February 2011. So after the Lehman Brothers crisis. So the principles were developed by the Task Force on Financial Consumer Protection. And then it was endorsed in November 2011. So last year in December, the HKMA, SFC, and OECD had the Asian seminar here to promote those principles. Under Principle 9, you have complaints handling and redress. So here, consumers are to have access to adequate complaints handling and redress mechanisms that are sort of accessible, affordable, independent, fair, accountable, timely, and efficient. And not to impose unreasonable costs, delays, or burdens on consumers. So this is a need to have a recourse to independent redress process, right? So it's a two-tier process. What you have in Hong Kong now is that if you're a consumer of financial services, if you do have a complaint, you go back to your institution. The financial institution, have the right to try to resolve it within 60 days. And only if it's not resolved during that time that you have a choice to come to FDRC. So we work very closely with financial institutions to make sure that they try to resolve it, and if not, come to us. So we have a number of guiding principles, and the principles that guide us in our work, everyday work, is that we insist that there is independence, we are impartial, we actually help both sides. We help both our members, which are the financial institutions, and also the consumers to try to negotiate for a settlement agreement, okay? And that improves the trust and the communication between them. We are accessible, we try to be user-friendly. All our processes, we try to make it very streamlined and simple. We are efficient, so we deal with the cases very quickly. So we've got timelines to do everything. So it's more efficient, it's shorter than going to court. And we're transparent. So, we have, we're going to produce an annual report, but we do have confidentiality and privacy obligations. For example, we're not going to name the name of the institution, for example, bank name. We'll call it Bank A or something like that, right? So we do make sure that privacy obligations are met. Okay, right. So we try to work towards a win-win solution. And thank you very much. You can go for morning tea. Thank you.